Well, good afternoon. How's everyone doing?
Great.
You look really excited. I think it's the topic because it's just so sexy. But anyway, my name is Adam Hull. I'm the chair of the venture capital group at Polsinelli. You can tell I'm the venture attorney versus the healthcare attorney just by our attire. But Polsinelli is a huge giant law firm, and we're all over the place, and that's about as much interesting stuff as I can tell you about a law firm. So most of my practice involves representing venture capital funds. Our group does a lot of early stage startup work too, but my practice comes from the money side. And so anything we're talking about, I'm seeing it through that lens, how we look at companies that are coming up in this space, how we evaluate them from a valuation standpoint, how we do diligence, and how we structure deals. And this is Matt Lipton.
So hi, yeah, I'm Matt Lipton. I'm actually the other end of the spectrum. I just left a big law firm to go solo, which I had done previously as well. Mostly healthcare focused in my practice, all transactional, so I don't know how to sue anybody. If I'm in a courthouse, something's gone terribly wrong. But at the end of the day, it's mostly early stage companies for me, and anything in the provider space. So I don't really represent insurance companies or hospitals, but physicians and all their kind of businesses. That's mostly what I do, with a little bit of private equity thrown in, and then just a handful of really esoteric out there high net worth clients. So a mixed bag. And I've actually been a serial entrepreneur myself, so I've had several startups, and I have 2 or 3 going on right now as well. So understand that side of the business as well.
Just give you a little context here too. For most people who are starting up a company in this space, a firm like mine is too expensive. So I want you to understand I'm not trying to get business from anybody in this room. I need more people in this ecosystem to do it right, so that when we come in and look at them later, we're not rebuilding it all. Most of the things that you need to do properly to get to a Series A have to do with knowledge, not money. So it's not cost prohibitive to do this stuff right. You just need to know to do it. So if you have questions as we're going along, please ask. I want information out there, but I also want to tell you that neither one of us represent you. We're not your attorneys, so I have to give the normal lawyer qualification on that. But happy to answer questions, and as we're going along, given that we have a pretty small group, please raise your hand. Don't hesitate to interrupt us. It'll be more interesting, and otherwise it'll just be us doing this. But the last thing is, a lot of the stuff we're going to talk about here is going to feel kind of academic. We'll try to keep it 30,000 feet, try not to use a lot of regs and statute references. But the important thing to think about if you're going into this space is none of this is academic. This is about money and control of your company. If you get this stuff right, you will have better valuations, you will have better exits, and you will retain control of your company longer. It's not academic, it's about money and control. So we're going to split this into 2 kind of pieces. Matt's going to talk about stuff that is very specific to healthcare. I'm going to be focused primarily on things that you need to know if you're doing a startup in healthcare, but it wouldn't matter if you were in healthcare or not. A lot of the companies we see in this space get so myopically focused on the regulatory scheme or the interesting tech they're building out, and they lose sight of the fact that you still need to build this a certain way. They need to look exactly the same as every other company that's coming up in the space in order to be fundable. So with that in mind, we'll get started. So I'm going to start with some boring stuff. When you form a company, whether you're doing healthcare or anything else, if you're going to try to be venture backed, which most startups are going to try to be, you need to be set up the right way. You need to be a Delaware C Corp. There are people who will tell you LLCs. LLCs are fantastic. They are the Swiss Army knife of entities. They can do anything. They can be built like anything. But because of that, they're very expensive to maintain. Nearly every statute that involves LLCs, it starts with unless otherwise provided in the limited liability company agreement, and then it gives you a rule. So almost every statutory rule applicable to LLCs can be drafted around, which means as the lawyer's reviewing the docs, I got to read every single word in that document. An investment grade LLC, one that's good enough for us to put money into, is going to be 50 to 100 pages long. And a lot of that's going to be tax, because an LLC is a partnership for tax purposes. Again, that's what makes them great, but also makes them expensive because you need $1,200 an hour tax attorneys to review them. People like investing in Delaware C Corps for 2 reasons. One, they're super simple. Everyone knows them. Everyone can redline the docs against the last 60 deals they've done. And the Delaware statutes surrounding corporations are so well fleshed out, and you have the best court system in the country that are interpreting them all the time, that whatever your issue is, we can look at the Delaware Chancery Court's rulings, tell you how they're going to treat your issue. There's a lot of precedent, so we know they're going to handle stuff. If you are wanting money from VCs, you need to be a Delaware C Corp. The exception is going to be if you are going to be a life sciences company or something that you're going to bootstrap for a long time, a lot of your own money in it. If you're an LLC, you can actually take losses personally at the beginning, and there's a huge advantage for some people in doing that. That is a narrow set of circumstances. If you're not going to go down that road, just make it easy. It's a Delaware C Corp. But I do want to tell you why it matters a little bit here. You're going to hear people talk about double taxation with C Corps. It does matter. This is tax, so I know it's boring, so I'm going to do this really fast. A corporation is a tax-paying person for federal tax purposes. So when a dollar comes into the corporation needs to pay tax on that dollar. Say 20 cents goes out. Now you have 80 cents. If the 80 cents goes out to the stockholders are they're going to pay tax on that dividend. So you get taxed 2 times. That sounds terrible, but the corporate tax rate's so low right now, it's not that big a deal. When you switch to an LLC, the company is not a tax-paying person for tax purposes. So when the dollar comes here, whether or not that dollar actually goes out to the owners, it's deemed to have gone to them. They're the taxpayer. So you only get taxed 1 time. When that dollar comes in, the owner is going to pay tax on it like ordinary income, like it came in your paycheck. 30 cents goes out. When you aggregate this stuff together, an LLC is a more tax-efficient entity than a corporation, but that doesn't matter unless you're actually putting money out to the owners. If you're going to be a venture-backed company, none of the money you make is going to the owners until you exit. You're going to have salaries, but you aren't just pushing dividends or distributions out to owners. All the money stays in the company to help build it until you get to an exit. So you don't really care that much. It's not that different. The last thing, S-Corps. If you have an attorney or accountant who's telling your startup to be an S-Corp, don't work with them anymore. They don't know what they're talking about. S-Corps are interesting because they have kind of a dual nature. They get taxed kind of like an LLC. The company's not really paying tax, but you're still a corporation, which makes it easy. The problem is there's tons of rules surrounding S-Corps. You can only have a certain number of shareholders. They all have to be people, and that's the biggest problem. No investor is investing in their own name. It's always coming through an entity, either through a fund or a holding company. Basically, if you form an S-Corp, you can't raise capital. The other problem is you can only have 1 class of stock. So you can't create a preferred versus common setup, which we can talk about, but that makes it really hard to raise money as well. So just stay away from these. They just mess everything up. Be a Delaware C Corp. It's easy, it's cheaper, it will just make things quicker. And almost everything in VC is a path of least resistance. Do it the same way everybody else did their deals. What you are doing in inventing something cool and coming up with a disruptive business model or disruptive technology, that should be bleeding edge. What we do should be boring. It should be the same boring thing everyone has seen over and over and over again. And if it's done right, we cost less. So keep that in mind.
So shifting gears to the healthcare side specifically, a couple things I want you guys to think about. It starts with what's the nature of the product or service you guys are developing. So is it a drug candidate? Is it some kind of immunotherapy? Is it a device? All those things matter an awful lot for a variety of reasons, predominantly for FDA approval purposes. So that's the big bugaboo for anyone who's in those spaces. It takes a lot of time and a lot of money to run those traps. So you need to determine first, what do I have and what does it mean? What do I have to do to get it approved? So for example, in devices, there's multiple classes of devices. They each have their own requirements. And 1, 2, and 3 are the classes. The farther up the chain you go, the more cumbersome it is, the more expensive it is. So that's an important first step is, what is it I'm developing and what's required? If it's a drug, the story is even a little bit worse, frankly. It's incredibly expensive and takes an awful long time. You're talking about preclinical and clinical work. It's just very expensive and, again, time consuming. So you need to be aware of what you're getting yourself into right at the outset. As far as the timeline and expenses, that's where I tell a lot of startups to start. It's what's it going to take, what are the milestones, how do I determine what makes sense as far as my fundraise based on those particular characteristics. Reimbursement also matters. So you built this wonderful thing, who's going to pay for it and how? So is it going to be sold to providers? I mean, are insurance companies going to pay for it? Is the government? All those things really matter. If it's going to be something Medicare is going to pay for, is there an existing code that you can fit under? If not, do you have to go get a new code? Yes?
Sorry.
No worries.
So if a code exists for a like, so we do health technology. Sorry, my words are just,
no.
Red Bull is needed apparently. Mainly like a health symptom tracking app for chronic illness. There's a code that exists already. do we need to, how, this might be too robust of a question, but if the code exists, how do you prove it would work for yours? Does that make sense?
It does. Well, yeah, I guess if I understand what you're saying, it's kind of, there's a code that seems like it might be applicable. Is it, is the question, more or less?
Mm-hmm.
Yeah, it's honestly, it's very case by case, and so it's a question of getting the exact descriptors from that code.
Okay.
Ultimately, sometimes it makes sense actually to reach out to the government, believe it or not, and say,
That's what we will.
here's the deal.
Okay.
And if you need help with that, we've got some connections.
Awesome.
That's always where I start, and it's always on a anonymous basis. Hey, we think this. What do you think? But yeah, it's important because I mean, if you don't know that going into it,
Right.
and you find out after the fact no one's going to pay for it, that's a problem. And I've seen that happen consistently. So yeah, I mean, obviously trace the money, figure out what you need to get paid. Other concerns from a healthcare regulatory standpoint, we referenced the FDA, HIPAA. A lot of folks are in data aggregation these days, right? So it's, I'm going to get all this healthcare data, and what am I going to do with it? Well, X, Y, and Z. Well, guess what? I mean, you may be subject to HIPAA, depending upon what data you're gathering and what you're doing with it. HIPAA is just a privacy statute, but it's got some teeth to it. Very, very important to know that you're honoring it if you're collecting that data. And again, I'm seeing that a lot with predictive analytics companies that's coming up over and over again. I'm actually seeing some Stark and anti-kickback questions come up these days as well. If you're not familiar, so Stark is a statute that deals with physician ownership of entities that they refer to. As docs get involved in ownership of some of these startups, you can have problems. The question is again, does it fall under one of the categories that's covered by Stark? And if so, what's the nature of their ownership and what are they doing? Are they referring back to that entity? Anti-kickback could be the same thing. It's like, hey, I'm going to cut you in for equity in this deal, doc. You're going to help me get this thing stood up, be an advisory director, and oh, by the way, use it and refer to it. So again, it pays you back, pays you well, it serves you well to analyze those issues on the front end as you're going into it to decide how to best protect yourself.
Excuse me.
Sure.
On those last two topics, is there any precedent in your experience of someone who's just selling an FDA-approved device through their channel? So not the OEM, but just basically selling and making it available. Is it just a matter of ensuring that the liability for the channel company is covered, or are there actual other rules for just sales channels for distributing?
So basically just being a distributor?
Yeah.
No, yeah, you can do that. I mean, again, to your point, it's going to be products liability coverage you're going to need.
Okay.
And then again, you want to vet and make sure that they actually have the FDA approval, the clearance that they say they do.
But
Right, because that comes up.
And also on the HIPAA topic, is there any special consideration for that distribution channel?
Not necessarily on the HIPAA side. I mean, then you're going to have what's called a business associate agreement, which is basically here's the rules between you and me as I'm collecting this data, and that just it governs what you do with the information once you collect it. That will also track the HIPAA statute itself.
So I think an upshot of some of this too is anytime you are collecting, storing, transmitting personal healthcare information, you are going to fall in. It doesn't matter what you're doing. If you are having that information, you need to be concerned about these schemes. So with all of these companies, we run into who really are the founders, and the problem with a lot of healthcare startups is they involve experts early on as advisors, things like that. Somebody's going to come in and help you figure out how to get through the FDA process. Physicians get involved, things like that. There's a difference between someone who is a founder and somebody who you're paying to provide a service by giving them equity. That's not a founder. That's just someone who's not taking cash, taking equity. You got to treat those people very differently, and you need to figure out who those people are. I think there's a tendency with a lot of companies to go, well, there's three of us, we're buddies, let's just split up a third, a third, a third. That is toxic. It will not, you will have so much resentment for that a few months later because not everyone's producing the same amount of value. They never are. So the only time you can have a conversation about how are we determining our relative values? How do we figure out what happens if you leave, or if you leave, or you have a kid and you got to move, whatever it is? How do we disentangle ourselves without blowing the company up? And one of the biggest issues right now is founder risk. And this particular generation of entrepreneurs, we're seeing founder risk we didn't used to see before. And what I'm talking about there is people who quit between the Series A and the B round because it gets really hard. Founder teams that just can't work together anymore. And a lot of this has to do with it not being set up properly at the beginning. The only time you can have these conversations is when there's no money involved. You need to think about your initial organizational documents as a prenup. We stop getting along, how are we going to handle that? And the more you lay out how things are going to work at the beginning, the less likely you're going to have fights later because we already have a roadmap for how we're going to resolve this. Again, most of this stuff is available in the form docs that almost everyone uses for these kind of companies. If you walk away from the company, you get to take your equity with you. You need to go through that stuff. The other thing is, who can actually do the roadshow? Who can raise the money? Who's the Pied Piper that people are going to buy into? You need to have that person. If you have a bunch of geniuses coming up with great intellectual property, but no one can speak to a business person, you have an incomplete company. You need to have all of those pieces.
Yeah, our question is about founders. So sometimes for the pitch deck, you always find the teams as investors. Sometimes you look at the company with solo founders. So, oh no. So what about the case such as if just founders, just solo founders, how that can makes this teams look like, oh, this is executable. What's your comment?
So I think that analysis depends a little bit on where you are in your life cycle. If you're the sole founder on day one, well, that's not an issue. You get to the point where you're trying to raise a Series A and you're trying to raise $10, $15 million. How are you going to deploy that capital in the company if there's only one of you? You can't really execute at that point. So then we're looking at who are you bringing in. And if you are still the only founder, you may have 100% of the company, but you brought in a bunch of people to help, then what we're concerned about is how sticky are those relationships. Do we have some stock options there with vesting provisions that make it really hard for people to leave? I don't care who the founders are, as long as anyone we're treating like a founder truly has drank their own Kool-Aid. I want founders to be insane. You want people who think, there's no reason to ever put money into a company unless the founder thinks they're going to change the world. Most of them are wrong. But if you don't feel that way, there's no point in having the conversation. Drinking your own Kool-Aid, believing you're going to change the world is necessary, but not sufficient. But we've got to start there. Yeah. So if you have a founder who's all in, putting everything into a company, and there's no other founders, that's fine, as long as the other key people are properly incentivized to stay with us to an exit and be focused on the exit and the money they would make then, and not on short-term compensation.
Okay, got you. Thank you.
Yeah, the only thing I'd add to that is, and I see this a lot, it's the founder who's part-time. Like, I've got a day job, I'm doing this nights and weekends. That's fine to a certain point, but at some point, especially raising any money, the first dollar, people want you to be all in.
Yeah,
right?
If you need to keep your job at Starbucks to pay your rent,
right?
That's fine. In fact, we like that kind of sweat. But if you're kind of still working at the CPA firm,
right,
so kind of pursuing a career, you're not all in.
Right, you got to burn the boats.
All right, so this is another thing that isn't specific to this industry, but you need to know it, is how do you get equity to people who are not there on day one? You can't just hand people stock. If you think the company is, say, worth $1 million and you hand me stock worth 10% of the company, the IRS says I just got $100,000 in my paycheck. That's not real money. I mean, the value of that stock is not real. So you need to make sure that however you get people equity in the company is done in a way that is tax efficient. And that's why we use stock options. And the way a stock option works, for anybody who doesn't know, is you get a contract that says once vested, which is usually a time-based thing, you can pay a certain amount of money to get a certain number of shares. That's the option. What we care about there is that the price you pay to exercise that option, as stated in the agreement, that is equal to or greater than fair market value on the day you got the option. So if today a share of common stock is worth $1 a share, my stock option agreement has to say I can buy, say, 100 shares at $1 per share. If it's below fair market value, you just gave me something that has present day value. What you want it to be is it has no value today. It's as the company increases in value and gets up to $10 a share, you then get to pay $1 for something that's worth $10. You get $9 a gain. That's great. But you need to make sure you're equal or above fair market value. There's a lot of regulatory pieces of this, 409A, there's deferred comp issues, none of which I don't want you to pass out, so I'm not going to talk about right now. Happy to answer questions on that. But you need to understand that works, and I would encourage anybody who's doing a startup in this space to put together an option plan, which is not expensive, right at the beginning, so that you have that ability to put that out there. If you're an LLC, you can do profits interest. They work similar, but they kind of come from a different direction. But most of you aren't going to be LLCs, so I'm not going to spend a lot of time on that. But one thing I do want to talk about is phantom plans. We call them phantom equity plans. Companies never call them that because it sounds super sketchy to the people that are getting the awards. What most people call them are equity equivalent plans. And what this is a cash bonus plan that looks and feels like equity. So I can give you 100 phantom shares of phantom stock and say that's worth 5% of the company. What that means is when we actually have an exit, I'm going to give you a cash bonus at that time. You don't actually own any of the company. I'm going to pay you out a bonus as if you had 5% of the company in the exit. So from the recipient standpoint, it looks and feels like equity. It's incentivizing the same behavior. It's taxed as ordinary income, not cap gains, so that's different. But from the recipient standpoint, I have no tax liability when I get it. You can give them out like Skittles. You don't need to know what the company is worth on the day you issue them. They don't show up on your cap table. It's just a potential liability in connection with an exit. Phantom plans are super cheap. They're really easy to put in place. And the nice thing about it is you have to be present to win. So if you leave the company, you're leaving behind that potential bonus. Where with options, it gets more complicated. There's a lot more rules that apply to this. This is just, if we have an exit, I'm going to give you X amount of cash. This is how we determine that. It's really easy. It's a good way to incentivize non-execs. So, you know, anybody who's staff, anybody who really aren't trying to make them feel like they're an owner, you want to give them some upsides, a piece of an exit, this is a nice way to do it. It's cheap.
Okay, well, let's talk about a couple things actually near and dear to your heart, because this is something you need to take care of before you go see him, Series A and beyond. Intellectual property. So you've come up with your new swell invention, whatever it might be. What are you going to do? How are you going to protect it? Well, obviously the number one way to do that is with a patent. Starting with, is it patentable? So that's a determination that has to be made out of the gate. There's a number of ways to run searches. You can run a search to see if there's something that's already in that space, if there's something directly on point. You can also get what's known as a freedom to operate opinion. So you can see whether or not you can infringe on somebody else's. So step one is, can I patent it? If not, can I still go out and do what I want to do without infringing on somebody else's? So those are the kind of things you need to be worried about. Confidentiality and keeping things under wraps is important. So as you're going out and having these meetings and talking to people, you've got a year from the date of first publication to go out and file your patent. And you know, the challenge would be you have a meeting, you think it's confidential, someone talks about it, and now the clock's running and you're not even aware of it. That's a problem. So I encourage folks to sit down out of the gate, figure out your patent strategy before you start taking those meetings, before you start talking to investors and those types of things. So in addition, in some foreign countries, you don't have any kind of grace period at all. You don't get the year. So if you've already had the conversation, it may be too late already to file abroad. So you need to get that figured out. Additionally, we have what's known as the first to file rule here in the States, which is, you know, hey, if somebody else has got a similar idea, it could be a race to the patent office, and the first person to put the patent application in is going to get the rights. And so that could be a concern as well. So I encourage you all to really think about this out of the gate. It's really important, and obviously, in this space, in healthcare especially, I mean, IP is the most valuable thing you've got. So as I said, develop an overarching patent strategy early. I mean, sit down and take the time as you're putting your formation documents together to think about what it is I'm protecting and what's my overall strategy. What's my budget, what's it going to cost, in what order. I do tell people to at least consider provisional filings. You know, basically it's put a stake in the ground, it's not a full-blown patent application, you've got a year to go back and fix it, but at least then you've got something on file, it's much less expensive, and you've started the process. And that helps you with the first to file rule. I also tell folks to consider PCT filings. Basically what that does is let you get into multiple foreign countries out of the gate. You do pay per country, but there's one central repository that you go through. It makes life a lot easier if you think you need to file abroad. Other IP things to think about. Trademarks matter, trade names matter. You know, if you've got some art, unique logo, unique name, you want to protect that if you can. You obtain rights to a trademark just by using it, but filing it's better. So go to the USPTO and file the trademarks and protect them as best you can. It's not required, but as I say, it puts everyone in the world on notice that you've got a trademark, and that then puts them at risk if they decide to infringe. Trade secrets, I also tell people to give that careful thought. You know it, you keep the knowledge internal, don't share it with anyone else. That has value as well. The challenge is people leak, and I always assume things are going to get out. So if you're basing your entire strategy on it being a trade secret, that's probably not the best way to go, but you can at least use it as a partial strategy. Coupled with that last point, which is employment agreements, invention assignment agreements, non-disclosure agreements, all matter. So as you're bringing people into the company, those are the kind of things we encourage you to sit down and think through. If someone's going to come work for you in the R&D department, you want them to sign an invention assignment agreement that says, I'm paying you to come here and work, whatever you develop is mine, and then it also will have confidentiality provisions in there as well to protect that information on you go forward. So those are important things to think of as you're getting started.
How long is the statute of limitations on things like that?
To file,
Or like to, like sue, I guess?
typically a couple years.
Yeah, I had a boss try to sue me for a trade secret when it was something that was industry-wide, what we did, so. It was like an event.
Wow.
Well, on this, so what was your company doing again that you're thinking about?
So,
Just high level?
Symptom track.
Okay.
Symptom tracking.
All right, so what is the secret sauce of this for you?
I just had an intellectual property agreement with a former employer as a CNA.
Okay, but I mean, if you were describing your company and why it's special, why someone should put money into it, for example, is it an algorithm you're working with? Is it a platform that works better than others? What is it that's cool about?
So I mean, it's,
Communicates with the whole system.
yeah, it's communicating, and then what's going to be the trade secrets coming in a little bit.
So for a company like Predictive Analytics, for example, anything where it's not a device, it's not something people are going to interact with directly. If it's an algorithm, if it's a software process that's really the secret sauce of what you're doing, we're seeing people patent that way less. It's hard to patent in the first place. But for most people, and this is again coming from the fun side, we used to want to see a really robust patent portfolio. And if it's a med device, we definitely want that. If it's pharma, we definitely want that. But if it's more like what you're describing, most of the time the IP we want is going to end up being a trade secret. In part because by the time your patent goes through, you've moved to version 3, 4, 5, 6 by that point. It doesn't matter. Plus, that type of intellectual property is so easy to get around. If you could actually open up the box and see how you're doing it,
Yeah.
I could deviate from it just a little, get out from under the patent and be fine. So if your real intellectual property is never being seen by your customers or the public, they're giving you data, you're running it, and then giving them data back or making connections for them, that's something that really fits well in a trade secret regime. But to Matt's point, if you don't have a regime, and that's a specific thing, it is easy to leak. So what you need is something that says, these are the people who have access to it, these are the people who don't, this is how you gain access to it. Like for example, the recipe for Coca-Cola is known by 2 people at any given time, and they just don't travel together. That's a trade secret, there's no patent on that, there's no copyright, there's nothing. So you actually can do a lot of protection through trade secrets if you carefully control how that information comes in and out.
But my concern is like if a former employer came after me for developing or starting a company while employed by them.
So the stuff I'm always concerned about when we think that might be an issue and we're representing the money coming in is, did you develop it on a laptop that the company paid for? Did you develop it on a phone that they were paying for? They probably own it.
Right.
Or at least they can make an argument. That's what scares us. When we see stuff like that, we start chopping valuation down. Even if no one ever comes after it, it poses some risk.
But if you kept everything
Everything is firewalled and separate.
and very outside the scope of your practice.
You're probably not going to have an issue, but that's something we'd want to walk through. And then also, to Matt's point about getting invention assignment agreements, when I look at a company, I want it from everyone. I want the secretary to assign one. I want a proprietary information and invention assignment agreement to PIIA from everyone, and they're robust, and they really are saying what kind of amounts to work for hire. So I was talking about founder risk before. The big concern we have for founder risk right now is the trough of sorrows, which is what we call the period between Series A and Series B. So up until Series A, you're running on Red Bull, like it's 2 of them right there, Red Bull and adrenaline and living on people's couches and doing other side jobs and things, taking money from parents. You're doing whatever you can. That period of time, everybody's kind of on the same team and working hard together, and you feel like you're part of a tribe. And it's spunky and that kind of thing. Once you get to Series A, all of a sudden now you have 7 or low 8 figures of money in your war chest. But in order to meet the projections you promised your investors that were in your deck, saying you're going to do these things, you have to hire 40 people. You got to move into bigger space. Now your landlord's being a jerk. Someone hits their parking spot. Somebody grabs somebody inappropriately in the bathroom. Someone's suing you over IP. Not only are all those things going on, but you are no longer on the same page as everyone else in the company if you're the founder. It gets really lonely. I think the hardest period for any founder is that A to B period as a CEO, because you have no friends. You are now making more money than the people around you. You are given a different stature than people around you, and you don't have anyone you can talk to. You can't really expose your soft underbelly to the people you work with. and you can't expose it to your investors, they should, it gets really scary. And during that period of time, we are seeing founders of this generation of founders bail. So as a result, we're seeing a lot more funds say, you need to subject your own equity to vesting, the equity you already own. Let's say you own 100% of the company and we're going to come in and buy 20% of it, now you have 80. I want all 80% subject to 4-year vesting with a 1-year cliff. So if you bail on us a year in, you lose everything. I'm not giving you $10 million if you can walk away tomorrow, because this got hard. And it will. It will be the worst job you have ever had between A and B. And almost every company looks like it's going to go out of business at some point right there. And the ones that come out the other end, if you get past B, you're probably going to go big. So be ready for that, and think about that when you put your teams together. So when we look at founders, we're now doing more psychological background checks. We're definitely doing full legal background checks on people as well, to make sure we know who we're getting business with, because we're afraid of people leaving in a way we didn't used to be. We talked about all the IP stuff. I don't think we need to get into that more, except to say your third-party commercial contracts are a place for potential IP leakage, particularly in healthcare, that we didn't used to think about. If you prepare some kind of model, or you're providing a SaaS service for somebody, and you customize it for a particular client, depending on how the agreement is written, they might actually own the thing you just built for them, unintentionally. And some companies are purposely trying to make that be the situation at the end. So when you do, don't just think it's a simple thing. When you get somebody to sign on and start giving you data and you're providing data back, they may own something at the end. So we need to be worried about IP leakage. We're very concerned now about how you raised early money, your initial seed money. Did it come from your parents? How was it done? Were there unaccredited investors involved, which I'll talk about? And more importantly, do you understand the regulatory scheme that Matt's talking about before you came and talked to the fund? If you can't speak in an intelligent way to all the regulatory schemes that apply to your business, this is going to be a short conversation. You need to understand it, because otherwise your business model is flawed. If you don't understand that you actually are subject to HIPAA, or that you have an FDA requirement that that isn't on your radar, all your projections are wrong. And we're not really going to be interested in talking about it. So you need to get that stuff right before you go in the room. I would start building your data room right now if you're going to raise capital. It's really easy to find. I'm happy to send it to anybody who wants it. The form of due diligence request list that we usually send out for a fund. And it's all the kind of basic stuff you'd expect to see. You can go onto Dropbox or something and build a data room with a folder structure that tracks those requests. And every time somebody signs an agreement, upload it. Every time you have a written consent of the board, upload it. Just start populating it now, so that when you actually go to do your round later, not only is that stuff easy to find, it's findable at all. What happens a lot is we can't find the document where you gave equity to somebody 3 years ago, because it just got lost. It happens. So start building the data room now, because pretty much anybody who's going to do something in this space is going to have to raise outside capital, and that outside capital is going to go through this diligence process. So securities laws are really boring, so I'm not going to get into this deep at all, except to tell you they exist, and that you need to understand the presumption that federal and state securities laws start with. The presumption is anytime you sell securities, I'm talking promissory notes or securities, if they're not payable within 1 year, stock, safes, convertible notes, these are all securities. Pretty much anything you're going to use to raise capital is a security. In order to sell securities, the presumption is that it has to be registered with the SEC. Well, obviously that doesn't happen. No one's doing IPOs to raise 500 grand. So you need to fall within an exemption. The private offering exemption is what most people use, particularly the Reg D safe harbors. We call them safe harbors because if you meet this criteria, you meet the exemption. It's a pretty nice list of things. And if you go under 506B, which is what almost everyone does, you preempt state law. Because not only are there federal securities laws, each state has its own securities laws. And if you don't use the right exemption, 506B, you're subject to both federal securities laws and the securities laws of every state in which a person bought stock from you. Well, that's a lot of work to make sure you're complying with every single state. It's not reasonable. So you want to do it the same way everybody else does it. Be boring. The big thing you need to keep in mind there is two things. You've got to comply with the anti-fraud rules, and you need to not allow unaccredited investors into your round. The anti-fraud rules are easy. Provide all material information in a non-misleading way. That's it. That's the rule. So that doesn't require any specific disclosure. It's basically, what do you think your parents would want to know before they decide to buy stock in a company? If somebody's suing you over IP, you gotta disclose that. It's not just not lying, it's making sure you're not leaving stuff out somebody would need to make an informed decision here. Don't need to go crazy, just need to make it all available to them. Full disclosure. Don't hide anything from an investor. The quickest way to get sideways with a fund is for them to find out 6 months later, you didn't tell them about something. Most of the things that you're hiding, they can help you solve anyway. So these aren't your enemies. They should be your partners if it's done right. That being said, there's a lot of bad funds, but the funds that are established that you're likely to see in any real round shouldn't be like that. Unaccredited investors are people who really shouldn't be doing this investment. What we're talking about people are people who have less than $1 million in assets, excluding their house, or make less than 200 grand a year individually, or less than 300 grand a year as a couple. Those people can't afford to be investing in VC companies, or companies that are likely to be VC backed. You don't want to take their money. If you take their money, one unaccredited investor comes in, you now have a litany of specific disclosures you have to do. The cost of complying with the securities laws that are involved when you have unaccredited investors will far outweigh the amount of money you're going to raise from them. It's not worth taking 20 grand from somebody when you have to spend then 50 grand on me doing the disclosures to make it work. And if you provide those disclosures to one potential investor, you got to go to all of them. So now all these other investors that were never going to ask those questions, now we're getting this book, like it looks like an IPO, it's terrible. Don't take money from unaccredited investors, it will plague you in every single round you do all the way to the end. Because we're going to be asked to write a legal opinion later on in a round, and we're going to have to say you comply with securities laws. Well, the law firm can't do that if you had unaccrediteds in early and you didn't do all this extra stuff. So just don't take it. Last thing.
A question about
Yeah.
accredited investors. So such as a founders, they probably doesn't need that $1 million, but the investor, their own money is like savings for that.
Founders are different. Your founders are part of the offering. So this is when the company's selling stock to third parties to raise capital. Don't worry about it from the founder side.
Oh, okay.
When you do, but it does apply to like employees. If you have someone working at the company who wants to put cash in, you are concerned about the unaccredited investor thing. So we've got to get them in a different way. That's why, again, we use stock options and things.
Okay.
So
Thank you.
the last thing, and this is a big problem in Texas, more than almost anywhere else, is unregistered broker-dealers. If someone comes to you and says, hey, I have a Rolodex of rich people, I'll help you raise a bunch of money, just give me like a percentage of that, what I raise, or give me some equity in the company for helping you raise all the money, that person is taking a transaction-based fee. And federal securities laws says that person needs to be registered as a broker-dealer. None of these people are. If they're coming to your tiny company and offering to help you raise 500 grand or $1 million, they're not a broker-dealer. They wouldn't have spent the money and the brain damage to get registered. Not only are they liable for having done it, the company's liable for having used them. And you could end up having to give all the money back to all the investors, which you won't have anymore, you'll have spent it. So you can't do this. They didn't used to enforce this, but in the last 10 years it's become heavily enforced, and you still have companies with like 20 employees who this is their whole business model. And they will shout up and down that what they're doing is legal. It's not. So stay away from those people. They're usually wannabes anyway. This is the other thing, I've yet to see in the last 5 years a company that has anything novel going on that's interesting with a decent management team not get funded. So if you can't raise capital, there's either something wrong with the company, something wrong with the founder team, or you aren't trying. Because there's never in history been this much dry powder in the funds to invest in companies. The hardest thing is to find good targets right now.
What's dry powder mean?
Money available in the fund to invest. So, I mean, there's way too much money and way too few good target companies. It's hard to raise seed money, but once you get to Series A and B, it gets, I don't want to say it's easy, it's always painful, but it's just there. There's a ton of it. Technology and the securities offerings, this is becoming a big problem. People are raising capital and then they put on their Facebook page, hey, we're raising money, you should invest in our company. That's a public solicitation. That's the same as putting it in a newspaper. You just blew your securities exemption. So if you're going to raise money, it's going to be a private offering or it's going to be an IPO. I mean, you got to remember what you're doing. So if you're going to raise money through a private offering, you cannot engage in public solicitation. You can't put it in the paper. And if you put it online, it's the same thing as putting it in the paper. So don't do that. We have had now, twice in the last year, had to shut offerings down because somebody in the company went on to Instagram or Facebook or LinkedIn and talked about the capital raise in a public forum, you just killed our exemption. We had to give all the money back, shut the whole round down, and start over again.
You're way
It is
over my
painful.
head.
What's that?
You're way over my head. How does that translate to nonprofit world?
Doesn't at all.
Cool.
Okay. If you're going to raise capital, you cannot go onto your Facebook page or Instagram and tell the world we're
Right.
raising money.
But why, how does it affect security?
So in order to fall within the private offering exemption from securities laws that allow you to raise capital by selling stock without doing an IPO, it needs to be limited to offerings that do not involve public solicitations.
Is that the safe harbor thing?
Yes, it's one of the safe harbor requirements.
Okay.
Now there are ways to do offerings that allow for public solicitation, like crowdfunding or 506c, but most of you aren't going to use those. So the important thing is if you're getting ready to raise money, everyone who works at this company needs to know not to talk about it.
Okay.
Shut it down. Go on to Carta or CapShare. There's other offerings too that are web-based cap table management programs. What that means is your stock ledger, everyone who owns things, are on a website that's built for that purpose. You can do your stock option issuances through there. It's all e-signed. It's super easy. If you do that, it's not expensive, but when you go to actually do your Series A round, and usually by that point you've done like multiple rounds of convertible securities, safes, and notes and things, it's so hard to model that well. You can do it through those platforms and it'll be right. But also, founders are really good at a bunch of stuff. They really suck at maintaining Excel files. So don't try to do this on your own. Don't pay us to do it. It's a waste of your money. Pay a little bit of money to onboard to Carta or CapShare or a similar platform. Whatever attorneys you're working with should get a discount anyway for that and make it cheap. And when you go to do your stock option plans, you should be able to get your fair market value, your 409A valuation, once a year as part of your subscription. And that saves you a ton of money too. So use those. Last thing is form docs. Form docs are great. The National Venture Capital Association, NVCA. Go to that website. All of the docs you're going to use for a Series A round are there. The forms are there. They're free. You can download them. That's what we all use, and you should be able to redline the docs for your financing against those docs. Read the term sheet. All the footnotes and stuff. It'll tell you all the terms you're going to have to negotiate in a pretty straightforward way. Know those docs. Outside of those, I think Matt would agree, don't just download stuff off the internet and start using it. It probably was fact specific. I mean, you've got to see it in a business associate agreement. If you download it, it's going to be wrong.
Sure.
IP assignment, it's going to be wrong. So don't do that. But National Venture Capital Association, those docs, they're great. And then the last thing is crowdfunding, funding platforms. If you're really serious about raising a lot of money and going through a venture-backed process, right now in today's current state of things, crowdfunding is probably going to kill your ability to raise money from venture funds later on. We don't want to invest in companies that have been through a crowdfunding process. There's too many stockholders, too many people with just a little bit of money in, too many unaccredited investors. And again, because there's so much dry powder, if you couldn't raise money through a traditional process, we want to know why. And it's usually because something's wrong with the company. Something's wrong with the idea. So don't do crowdfunding if you can avoid it. So this is the part where you can just ask questions. Because we've been blathering most of the meeting. Yeah.
I'll go back to your statement about sharing if you're raising money in a public forum.
Yeah.
So that sounds pretty airtight. Like no one on the founding team, the co-founders shouldn't say, "Hey, we're raising money." Like you can talk to people that you're targeting, but that's pretty locked in. You can't really do that.
So everything you just described, you can do. You can go pursue individuals. You can go after funds. That's all fine. Pitch days, like an accelerator, are kind of understood to be okay. What you really don't want to do is be putting stuff on the internet. That's the biggest pitfall we have because people don't realize that it's the same as putting it in the paper. For the most part, we tell people don't let people below your C-suite or specific key employees know that you're even doing the raise until you've got a term sheet in place. It's hard to manage expectations when people start thinking a lot of money's coming in. They all think their salary should go up too. And you are not responsible for what third parties do. So if someone you approach about a round then goes and talks about it, it's not your fault. But if someone in the company did it, it is your fault.
Thanks.
What about those of us that are doing a 401c3 organization? myself is that there'll be initially online business, but eventually be a 401c3, helping individuals with special health care needs, specifically PTSD and suicide prevention.
So you are probably not going to go through a traditional capital raise process because you're going to be doing this as a nonprofit, right?
Yeah, not-for-profit, I'm probably working with, still be working with insurance companies probably.
Yeah, so the capital raise side is totally different. I mean, you're going to be raising from foundations and through charitable donations and ideally through big foundations. None of these rules apply the same way.
Okay, that's okay.
You just get that check.
Yeah, just get the checks.
So you were talking about stuff like whenever you do like IP for an app or something, having every single person signing. How would you go about that if you're going through a third party, like a company you subcontract the building of the app? We have contracts with the company, but I'm not specifically sure who's doing what. How do you go about like signing that sheet of, oh, you're not going to go sell the IP?
Our company has an agreement with their company that we own the IP, but we don't have specific agreements with every single person that touches the IP.
Yeah, they're employees of that company, so it's
Okay, so that's fine.
you're dealing with the entity. That's fine.
Okay.
But you want to be very, very careful about the language around who really owns this, and can they make derivative products and sell it to competitors and do all
Yes.
that stuff's always scary. I mean, you see this a
Sure,
lot.
and development agreement, sure. Yeah, you want to just be careful in that. It's a work for hire, you own all the IP, and they're representing that nobody else has rights as well, as part of that document when you're signing the development agreement.
So great talk. So I have a question about, especially for the biotech or medical device startups. How do the early rounds, such as the seed rounds, and how to about value evaluation and value evaluation, how to evaluate and
How to determine the valuation?
yeah,
Okay.
it's kind of because the kind of negotiations, the steps, but sometimes you convert notes are safe, and sometimes I just want how much share I need, so percentage of your company.
So there's a couple things there. One, there is no possible way for an early stage company to really defend its valuation with financials or financial projections. Any attempt by an early stage company to do that is really just chimps throwing feces. I mean, it's garbage.
Yeah.
It's all about what we think is possible.
Yeah.
Okay. So don't allow yourself to get into a discussion with a potential investor where you're defending the valuation. At the end of the day, your valuation, when you're really early, is I'm willing to sell X amount of the company for X amount of money. Well, we're going to back into a valuation from that. That's as much logic as you're going to put into it at the beginning, because you can't do more than that.
Yeah.
That's it. So that being said, part of the reason that most early stage companies do not do priced rounds, and by priced round, I apologize if I'm telling you stuff you already know, but a priced round is where we say the company has a pre-money valuation, it's worth before new money comes in, say $1 million, and it's got 1 million shares outstanding, that's $1 per share then, is what we're going to sell. That's a priced round. Versus what's much more common for early stage companies, convertible rounds. So safes, simple agreement for future equity, or a convertible note. They work very similarly, and I can explain that if anybody wants, but the nice thing about both those options is you're punting the valuation question till the next round, because right now we're not going to agree on it.
Yeah.
I think this company's going to be worth $1 billion, and you want to, no, it's not even worth $1 million, you have nothing.
So your company right now is acceptable right now in the Dallas, the investor system right now?
Yeah.
Because, okay.
Yeah, so in the Dallas ecosystem,
Yeah.
but it's the same in the Valley, it's the same everywhere, that most early stage companies are going to do 2 or 3 convertible security rounds,
Okay.
and then do a price Series A.
Okay.
And the size of the early rounds are getting big. So we're seeing mid 7-figure convertible securities rounds we didn't used to, and the Series A's are starting to come in more like low 8 figures. So it's always just kind of moving. But convertible rounds are great because you don't have to negotiate all the same things.
Yeah.
Once you do a priced round, we're going to have to negotiate what your board rights are. Is there a liquidation preference? There's a menu of things we got to talk through. Again, see the NVCA term sheet because it'll have everything. We don't have to do that with a note or a safe, and it's so cheap to do those rounds for the lawyers. And there's very little diligence involved. It's real fast. So if you can avoid it, don't sell stock. Sell a convertible security until you're ready to raise at least 7 figures.
Sounds good. Thank you.
So something specific to the healthcare space, and it's probably maybe more Matt, but possibly yours as well, is data aggregation. And if you if you're collecting PHI, but you de-identified under the HIPAA requirements, I think there are 10 or 12 or 15 different key things you have to strip out. What are the traps or what are the pitfalls of aggregated de-identified data? And is that a whole nother session? So.
Yeah, it's at least a whole other session. But I mean, I always start with the BAA. I mean, that's where you begin and end with, with the underlying business associate agreement. Because the question is going to be, that stuff gets addressed there, right? What can I do with it? What can you do with it? Especially de-identified.
We've addressed it, and it has involved hours, days of negotiation with some big healthcare systems, and ultimately, you can de-identify it, but I guess it's BAA and the contract. It's a SaaS software system. So, has there been? I mean, some of that's so new. Has there been a lot of litigation around that type of issue of breaches around that type of data being used for other purposes?
I've seen it come up in negotiations a lot. I haven't seen a lot of lawsuits around it yet, but it always is now a topic of conversation.
Yeah, the big health systems are just absolutely paranoid.
Yeah.
For good reason. I mean,
No, I understand it's extremely expensive to fix, and when you're a small company, you have limited pockets to fix the problem. So.
And what do you? I mean, I think the next question is, what are you doing with the data? Is it a predictive analytics kind of thing, or are you using that information to help you make decisions?
We're just collecting it. We have millions of records, and it's data analytics, predictive analytics, research. Customers want access to it for potential research because it's nationwide data in a particular medical field. So it has future value both in research, but also maybe pharma companies or other companies might want to purchase it. So we want to have the data available because it's big data. And at some point it has value. So anyway, it's been an interesting issue to address.
Depersonalize, we're talking about. So let's say
Right,
I go and
then
use my page and everything, and then you just remove the individual component.
Right, no.
Yeah.
I would think that.
People are still fighting over it, though, believe it or not. Folks are saying, I don't care if it's de-identified, you're not going to sell it, because at the end of the day, you're trying to make money on it, right?
Well,
no, you're not going to do that.
Well, and it's not a customer. So UT Southwestern system, if they have, you're collecting data. One is if they leave, they want it all erased. Which, if you de-identify it in an aggregated database, it's no longer possible to necessarily, because if you put an identifier on that, then it's still identified.
Sure.
So you can track it. But they're concerned that it could be released, so get hacked somehow. But the thing is the limits, how you de-identify it, I don't see how you could ever re-identify it because it's year of birth, state, not down even the county, and beyond a certain age limit, you can't. It's like within the decade, I think 70 or 80. But so it's anyway.
I mean, this question gets in the weeds of HIPAA and PHI at a level that I'm not confident to speak to, but I can tell you from the investor side, looking at companies that are doing predictive analytics, after we deal with the regulatory piece of this, we're very concerned with where did the data come from, what was the contractual relationship between the person whose data it belonged to and who collected the data, and what were their usage rights with respect to that, and then how much rights do we have to maintain it, can we ditch it after a certain period of time. We're much more concerned about that piece, but the regulatory side, I just can't speak to.
Yeah. Well, the previous part is what's in the contract, not the BAA. The BAA is about protecting PHI. Once it's no longer PHI, it's not, because you de-identify it and aggregate it. So it's still
And a lot of the law around this doesn't exist yet.
Right,
So-
but yeah, as opposed to like Delaware corporate law has
Yeah.
been fully litigated. There
Mhm.
isn't any issue that's not been resolved, right?
Yes.
This is to be determined.
Yeah, I mean, I think once you de-identify, we have a lot more flexibility on what you do with it, and then it becomes a cybersecurity issue. How are you protecting it, and is that best practices compared to other people similarly situated in the industry? And that's the stuff we're always looking at. But I think most of it for a company that's doing what you're describing, it's the contracts with where the data is coming from, and then verifying the contracts they had. What was the person signing when they gave over that data? And was that a contract of adhesion? Meaning, did the person who gave you the data, were they able to negotiate in that relationship? Or was it something they signed when they checked into the hospital? And did they knowingly and intentionally give you their data? So that we're concerned about all those things, but no, and you may be able to speak to this, but I don't feel like I know HIPAA well enough.
Well, and that's, I think you're right on knowing that specific issue is really going to be in the contract,
Yeah.
or should be. If it's not addressed,
Well,
then.
you and I need to catch up anyway, so
Sure.
I want to talk about it
Absolutely.
in more detail later.
Sure.
Sorry, I keep just running my mouth.
There's like 4 people here.
So, the key with any health data is just from the very get-go being by the book, compliant, and having everything written out.
I mean, massively overgeneralizing, yeah.
But like,
But
who
the devil's
stores
in
your
the
data
detail.
from the start, and I mean, those kinds of things. If you're aligning yourself with HIPAA conscientiously, rather than a cheaper option, wouldn't that be the safe way to go?
Well, sure. I mean,
Okay.
best practice is always going to be more conservative. Fortunately, this is an area where a lot of big companies are dealing with the same problem. So we're seeing the evolving law move pretty fast. But what I would be starting with is, where's the data coming from? What was the legal relationship that allowed for the data to be collected?
Policies.
And then how am I getting data? What are my rights to use that data? And my obligation to continue to protect it.
That haven't spelled all out.
Yeah, and to what extent is it still identified with an individual, and therefore PHI? So all this stuff is scary because you mess it up. It's not a, it's an on-off switch. You either are doing it right or you're not.
Right.